Okay, as I review week 4, I want to remind you of hopefully where you're getting to because you only have about a week and a half to get there. So by now you should no longer be seeing law as automatic. It's no longer one thing. Power is not something that you possess. It's not something that you use by going and grabbing it. You're starting to understand that while there are ideals that are put forward as reasons to have the criminal justice system and legal system that we have today, that is not what actually happens. And that you're able to start to now to use language that, and particularly hopefully legal language, that helps you show the actual problems and maybe even start to get to think about what reforms you'd be interested in. And then most importantly, you're starting to refer to course materials and comparing that to your lived experience so that you can show your own legality narrative and that you can understand the two other legality narratives. Now, this week, I'm really trying to help you understand the malleability of law, how the legal precedents are used to support an argument versus somebody else's argument, which is also using precedents. So there's not one central law of which judges check and then apply it, but there's lots of interpretation that's going on. And then you'll hopefully start to see why there's gaps between ideals that you'd find in a textbook or in a K through 12, high school class, and what happens when you start actually studying the law at the undergraduate level. You're also going to want to see how this relates to the legal system and criminal justice system's goal of closing cases, and you'll start to understand that crime is socially constructed. It's not a bunch of bad guys and then good guys trying to catch them. It's much more complicated than that. And then finally, again, that you're demonstrating that you understand this from multiple points of view and that you've kind of left this naive or single idea. And so just to remember, the goal of the criminal justice system and then feeding into the legal system are to close cases. And so now I want to get into this idea of, well, why is this, right? So if you pay attention carefully to politicians, they'll talk about being tough on crime. You could even analyze what Eric Adams and others are saying right now, even though there's no evidence whatsoever that bail reform is actually causing any crime. In fact, all of the scientific evidence is showing that largely it is not affecting crime, but rather that, as we all know, the economy affects crime. They're still using this language. So the question is, well, why would they do this if it's unscientific? Well, it helps them get reelected. So your average person who votes is mostly paying attention to the news and the media. They're not going to criminal justice classes. They're not reading research articles. They're not studying these issues in depth. They're really focusing on one sentence kind of solutions. And so tough on crime helps voters feel better and makes it seem like politicians are doing something about a problem. And then, so try to remember then that police work for the politicians, right? It's a cute kind of thing to say that they serve and protect the public, and I'm sure many of them would like to do that as their motivation for going to work, but it's not realistic when we scientifically analyze the system. They work for the politicians. The politicians are the ones that control their budgets. They're the ones who decide what resources go, what their quotas are going to be, etc. So if we look over at this diagram, then the inputs into the system, it's a system, so it's got inputs, a process, and outputs, and then ideally it has a good feedback system. The inputs for police, because they're at the input level, they make stops, they make arrests, they detain people, but they also kill and harm people, right? So those are the things that happen at the first level of the system. There's a process in the system of where there's internal review, so police reviewing police officers. There's civil court cases. This is when I want to sue you. You usually think about this in, if I hit your car and we go to court. But there's lots of civil cases that have basically, did you have a duty to not harm me? And then, of course, you're more familiar with criminal court cases. And the process can involve all three of those. But as you can imagine, it usually involves only internal review. So what are the results of that system? Is that there's either a suspension. If this is an internal review situation, there's either a suspension or there's no action, and most of the time there's no action. In civil court cases, there's either liability or the case is dismissed. In most of the cases, they're dismissed. And then in criminal court cases, you're either found guilty or not guilty. On this one, there's usually just not any criminal cases, but in most of the cases that have come forward, there's been not guilty, and a couple cases in the last few years, there's been guilty. And so what's the feedback, whether the system is working or not? Well, it goes on public opinion in elections. And so because we keep electing people who are, quote, tough on crime, you're going to continue to see police killings. So then how do we explain this from a legal point of view, right? We understand it from a political point of view. We understand it from elections. We understand it from a policing point of view. Police are going to do what they're told by their bosses, who are the politicians, and the system isn't correcting anything, and so we understand that. But what explains it from a legal point of view? Well, Dr. Chapman, who works here at Kingsborough, is a police expert, so he goes into courtrooms and he testifies on behalf of not on behalf, but in situations where there's excessive force. And so he's been curious about this from the practical level, from his job, but then also from his job as a professor. So he did some research, and he found and argued that there are 3 doctrines within the court system, specifically at the Supreme Court, that encourage police to be violent. Now, this does not mean that it's encouraging them to think about being violent. It's meaning that it encourages behaviors that lead to violence. And so in other words, because there aren't any legal penalties within the system, police don't have to make any changes. Neither do the politicians, right? This whole system kind of keeps going. And those 3 are qualified immunity, summary judgment being reconceived or reapplied in this situation, and then this concept called respondent superior liability, which is basically the boss should be liable for the employee's mistake. So in this case, the city or the politician should be responsible for police excessive force. Now, this isn't a systemic argument. This is what we do as scientists, right, of criminal justice and of law. We look at systems, and so we understand through study, research, science, that systems influence behavior. So people behave based on the system that they're in. They play by the rules that they think exist within that system and the rewards and punishments within that system. So as academics, we don't look at invisible motives of human beings like many of you do, and obviously in social media they do. Because we don't have that ability, right? It's not scientific. I can't really read your mind as much as I can try to assume some of your motives. I don't know for sure. I don't have any scientific knowledge to support it. So this is more magic, superstitious, unscientific thinking. So we wouldn't be, Professor Chapman and I wouldn't be employed. We wouldn't be able to have this job if that's the kind of thinking we did. We have to do systemic, academic, rigorous thinking. So he also uses legal reasoning here, and legal reasoning includes a rule of a court. It makes an analogy, in this case to police excessive force, and then there's a conclusion using that legal authority, those cases. So I want you to note how in that reading, how judicial legal reasoning is different than popular opinion about police abuse, right? So a majority of Americans believe that police are abusing their power. But the legal reasoning makes it harder for police to be responsible. So you've got this really contradiction here. The court's not really mirroring what the people think. Some assumptions are that, why is it this way? Is that maybe people don't really want the police to be responsible. So we wonder, is this accurate? How might we measure public opinion more accurately? But as we do that, we want to think about the legal foundations. Now, I'm not going to go through this whole slide. I mostly just want to do this to demonstrate this is legal reasoning. The theory here, right, the immunity, qualified immunity, the theory, what he calls a doctrine that courts have developed over a very long time, is that a government agent shouldn't be responsible for harm from doing their job. So a kind of classic example we learn in law school is thinking about the IRS agent, right? So somebody doesn't pay their taxes, the IRS agent is doing their job, they order the property be seized, and then this person becomes homeless. Well, we shouldn't be able to sue the IRS agent because they were the cause of my homelessness, because I didn't pay my taxes. This is the general thinking, and it usually applies more to corporate situations, bankruptcies, and city governments. But it has merged over time, and this is Dr. Chapman's argument, is that even though there really isn't qualified immunity specifically for police officers, over time it has become that way. That police have been using this as a defense. The general idea of qualified immunity that I just laid out, they're using this saying, well, this is our ordinary duty, and now we're being punished for doing that duty, and so we shouldn't be able to get sued for excessive force or for killing people. And so what you have to start to think about as legal reasoning is what we start with is we say there is always this case, right, in what we call precedent, but the power within law really comes from, at least in this country, theoretically, it comes from the legislative branch, right? You learned that in your American government class, whether it was in high school or college, right? Is that the number one power is Congress or the state legislature. So they pass a law. Remember, that was the whole reason of having a legitimate government, is you elect certain representatives, they go to the Capitol, they argue and debate, and then they come up with this compromise, and then it's supposed to represent all these people. And so in this case, there's a law from 1871 following the Civil War as part of the Ku Klux Klan Act, which is what gives this concept of immunity. And so over time, people have used this legislative law in order to defend their actions, saying I shouldn't be able to be sued because I'm a government agent. And so over time, Dr. Chapman identifies 8 different cases in which this principle has been used, and that's what develops into this qualified immunity for police officers. And so basically it comes down to they shouldn't be held guilty or responsible for something that is in their ordinary duty. Now obviously you can have all sorts of political arguments with this, but what Dr. Chapman is showing you is that the courts have developed this doctrine through the use of precedent. Now there's also this other argument he uses to show it's not just precedent, it's also judicial procedure. So there's something called a motion for dismiss, but it also applies to the qualified immunity situation. Is it comes down to what evidence that I can put forward in order to hold the police officer responsible. So you're thinking, well, okay, there's videos showing excessive force. True, but not all of those videos are admissible in court because there are rules of procedure. There are procedural rules that allow for evidence, how it's going to be obtained, how is it going to be used, etc. But even further, Justice Samuel Alito, who's been in the news because of the Dobbs case in abortion, he made this idea that it really isn't up to the Supreme Court. He says it should go back down to the trial courts, and the trial courts should get to decide whether qualified immunity applies based on the particular use of force in that area. So in other words, in every single state, there could be a different standard for police behavior, right? So you could be more excessive in, say, California than you could be in Florida, for example. Those are probably bad examples, but you see the idea here is that each jurisdiction should be able to decide what they think excessive force is in that particular area. And so this leads to the way to dismissing those cases if that jurisdiction doesn't believe that the ordinary duty, the ordinary conduct of the police officer is excessive. And so that leads to this interpretation of the rules, not just the congressional law, but also of the procedure. And so in this case, we've got something called summary judgment, and in a nutshell, basically, if I'm the defense, you bring a claim against me and I'm the defense lawyer, what I do is I bring a claim saying you haven't presented enough evidence for us to go to trial. So in this kind of multicolored stage system over here, this is stage 1. Now I could also go to stage 3 here, right? So if you say no, if you get enough evidence to get past stage 1, then we start bringing our evidence forward, we start collecting more. I'll bring it the same argument again, saying that I want this to be summary judgment. I want the judge to decide that there's not enough evidence for us to move forward. Now, Professor Chapman is arguing that this shouldn't exist for these cases, and especially for what are called civil rights cases, where you're suing the government, you're suing the police because your civil rights were violated. So note, this is not a criminal case, right? So this is a civil case where you're suing for money damages. And so basically, judges essentially weigh the evidence that's presented to them at that point. Now, to be fair to the system, the judges are supposed to grant certain benefits to the plaintiff. They're supposed to take the evidence in the light that's most favorable to the plaintiff. But oftentimes, it's hard to get overwhelming evidence in a case where the police hold most of the evidence, right? So they're not churning over evidence, or they claim that they don't have it. Or even just in these situations, even when they could turn over evidence, they might not have it, right? There might not have been a camera in such a place. There's lots of information that is very difficult to obtain, and so getting a summary judgment at this stage is very likely, which means that you never get to stage 4 or stage 5. In other words, you never have a trial. And so most of the issues in police excessive force never actually go to trial. They get dismissed in earlier stages. This also goes to this idea of even when they get to stage 4 or 5, it would be easier to bring cases because you could look at policies of the police department or policies of the city government and sue them on that behalf. But the courts have not allowed for this, what's called respondent superior. The easiest way to think about this, I think, is that it's because I worked when I was in college, and I know most of you do as well. You work at a job and you have a boss, and so most of the time, in most situations, your boss is responsible if you make a mistake. And so if I was going to sue the business, I'm suing the boss and I'm suing you, but I'm also suing the boss. The courts over time have made it harder for you to sue the boss. It's harder to sue the police department and the city government, and so it makes it harder to prove the case, because I could say you had a deficient policy, right? It's not that the individual police officers violated a national standard or even a local standard like Justice Alito was suggesting. I could just say, well, they weren't properly trained. I can't do that if I can't have this, I get to sue your boss too. I can't say you weren't properly trained, because then that would get you off the hook. You wouldn't be found guilty or liable. So Chapman's main point here is that a standard that was less friendly to the police department, less friendly to the city government, would force police to have to take police violence more seriously. But these 3 judicial policies have made it less likely for police to change their behavior, because the precincts, the police departments and the city governments aren't making any changes. So we want to go back to this idea now. You should really fully understand that law is malleable, that the system, here's the judicial system, is very complicated. It's not as simple as a judge just looking at a so-called precedent and then applying it. What's really going on here is that the defense and the prosecution have their own case rules. They have their own previous rules, precedent, that they're arguing, and they're saying, Judge, you should rule in my favor because this situation, this case that we're in right now, is just like these cases where a judge said that I'm right. But the other side is saying the same thing. They're saying, no, Judge, this is not like those cases. This is like these other cases, and you should be saying that I'm right. And so the judge is persuaded one way or the other. They're saying, what is the evidence that I have? What are the best legal arguments? And then they make their opinion based on that. And just in case you're thinking, well, that's stupid, well, they don't have a choice. This is exactly what they must do. Because remember, they're going to be appealed, and they'll get overturned if they don't stick to the legal arguments that have been given to them. Now, very rarely a judge like Sandra Day O'Connor in Planned Parenthood versus Casey comes up with the third way, where they say, well, I've heard your arguments, but there is support in other cases that you didn't talk about, or I see it differently than the way you're arguing. I think the case was different than what you're saying, and so I'm going to put together this third way. So, for example, in Planned Parenthood versus Casey, she argued that there should not be an undue burden on the woman who seeks to get an abortion, and so the courts could decide what's an undue burden in future cases. The Dobbs decision, Alito, gets rid of that undue burden standard, so changes the precedent and goes back to, allegedly, in his opinion, precedents before the Civil War, so going back to the 1760s. And so precedent is not one thing, right? Precedent is lots and lots and lots of cases, and the lawyers and the judges use them in their arguments against each other. So in the quizzes, what you should see is the arguments that Dr. Chapman are making are that qualified immunity, summary judgment, respondent superior liability, these 3 judicial principles, these processes, are actually encouraging police violence. He's also arguing that, and I wanted you to be able to, this is now legal reasoning here, is which case is the one that was able to establish this precedent, and it's Malley versus Briggs. So about half of you got this correct. And then the Supreme Court determined that lower courts would be permitted to simply dismiss cases on the grounds that the particular use of force in that jurisdiction, so whether it's New York City or LA, San Francisco, right, whatever the practice is there. So something, again, could be more excessive in New York than it is in Chicago. And so again, this is going back to those politicians being able to say they were tough on crime, and the courts basically reaffirming that system. Now, to defend those judges, right, so on the one hand, it's obviously leading to police abuse, and it's terribly unjust and very racist. But on the other hand, it's sticking with principles of so-called democracy, of the majority will. And so you've got these contrasts that come up a lot in the legal system, and this is one of those situations. Now, the reason why I put this article together with this other one is because even in your answers in the discussion board and in some of the annotations, you're still sticking to this belief that courts are neutral. And so this has been found not just in your class, but in lots of legal classes where students, this is troublesome for most students because they seem this counterintuitive or alien. But as you start to understand that this isn't accurate, that courts are not in fact neutral, and that precedent is not one thing that applies and is what you're all saying here is predictable and all these things. I mean, this would be lovely if such a thing existed, but it's not. This doesn't exist. It's a lovely idea. This is what you're arguing here is the ideal system in which there's like one standard. But even with murder, you have to think, right? There's self-defense, there's insanity, there's I'm a police officer, so qualified immunity, there's justified killings, there's fits of passion, right? There's all these different exceptions we have to saying don't murder, right? And war, right, is another big one. And so, right, there isn't one rule, or isn't one precedent that you can just look to and say, oh, okay, I can solve every problem on the planet. Again, this is all based on argumentation and a bunch of different cases. And so you have to start to understand that's what we mean by malleability, is that lawyers are using these cases and these principles to argue on behalf of their side against another side. So of course the other side is doing the same thing. And those aren't the only two sides being represented. There could be dozens of sides that don't make it into a single court battle. So why do you continue to misunderstand this? Well, I understand you were taught this way, and this is the same idea, and kind of funny that not all of you got this, and the biased one is very interesting. But you've been told this in school and through media, right? So media and social media reinforce this idea that judges are and should be neutral. Again, it's nonsense. And if you watch the video I did before, I mean, it's not even, the neutral referee doesn't even exist in sports. So of course it doesn't exist in law, and of course it doesn't exist anywhere, right? So no human being is neutral and without bias. But people tend to want to believe that judges are, which is insane, right? It's very difficult to even imagine how that would work. The other issue is you didn't go to law school, right? So you're just now engaging in these ideas, and so as the more you learn about precedents, right, the more precedents you collect, right? There's thousands, tens of thousands of them. Then the easier it will be for you to see that, oh, there's not just one thing. You've never argued using precedent like lawyers do and law students do, and so you haven't had to actually go through this experience. In the 13-week class, I have students argue using precedent, and it's much easier for them to start seeing that, oh, this isn't what I thought it was. But probably the main thing is that you need to understand precedent is not a thing, right? Again, it's like you thought law was a thing, you thought power was a thing, you go to the store, you buy it for $3.99, you take it home with you. Precedent is not a thing either. Precedent is a word we give to previous case interpretations, of which there are multiple. And so it's not like digging into a box and pulling out, oh, I found the precedent, your side wins, right? Again, that'd be lovely, but it's not realistic. The main thing here is that a series of words can be interpreted differently by many people. And so we call this process in legal reasoning abduction, where there's a malleable rule, a rule that can go a number of ways. You use analogies, and you should definitely look up what an analogy is or study it on YouTube videos. And then we draw logical conclusions, plural, that are always in contrast with other arguments. And so this is the messiness or the malleability of law. Now, this is a great example. This is a pretty common example they use, but you see this 2, 4, 6, 8, 10, your brain says 12, right? Because I'm used to, this is a series, a pattern where I'm adding 2 each time. And so people say, well, this is correct because it's 12, 14, 16, whereas 13, 19, and 20 would be incorrect. And that's an example of confirmation bias. You're not seeking out objective facts. You're not looking out to see what alternatives are there. You're interpreting the information. You're saying, oh yeah, this exactly matches what I thought it was. You're remembering situations, like for me it was Little League, 2, 4, 6, 8, who do we appreciate, right? But you probably did this sequence somewhere in math before. And so you're ignoring any information that challenges your belief. So it might even be hard for you to look at this red box. Well, you said 2, 4, 6, 8, 10, and that's the so-called rule. But the rule could also be, objectively speaking, that the next series of numbers should be 3, 5, 7, 9, 11. And people who are good at math would say, oh, of course, or even coding or computers would say, oh, of course. But that's only one alternative. There's really unlimited alternatives to this 2, 4, 6, 8, 10. And so it only becomes the rule if you believe it and other people agree with it. But anybody who comes in and says, no, that's not the rule. The rule is to add 1 in each of this sequence. And then, you say, oh, okay, now I know how to play this game, right? But it's only because you thought the rules were one thing, and you have to be open in law to there are many interpretations of rules, and there's many systems of rules. There's not one system. So when I gave you the limits of law article and showed you that in the issue of patient dumping, this is really borne out, right? And you can see here I've put the map and then I've put the decisions over here, is that the decision is different in different areas of the country. And what I want to show you here is that when judges started looking to congressional intent, what they mean by, so we have a habit of thinking, oh, okay, this law, EMTALA for short, was passed in Congress, and so quote unquote Congress wants to stop patient dumping. No, not every member of Congress voted to stop patient dumping. Democrats voted to stop patient dumping. Many Republicans, I'm not saying they were okay with patient dumping, but they didn't want legislation to be passed. And so when you look at quote unquote congressional intent, you're not looking at the goal of Congress as a whole. You're looking at individual arguments that people made and trying to figure out your position based on that. And so what you'll see is, what I noticed when I did the study was that in places where those Congress people, largely Republicans, voted against universal health care, they also, the judges, voted against giving health care to these poor people in the legal cases. And so you see this political Republican getting appointed by Republican congressmen into the judiciary, into the judge's position, and then they start to behave that way, right? And so this is not shocking. This is not really surprising because they're friends. They know each other. Many of them went to the same law schools and other elite colleges. And so when you ask these questions over here, they're great questions, but the short answer is politics, right? Politics, and so judges aren't even remotely close to being neutral. And so what you start to see here is that, right, one thing that many of you were on the same page as I when I started looking at this situation is that, it's clear that regardless of what the politics were, the law came out this way. It says stabilized meanings requiring such treatment of an emergency medical condition as may be necessary to assure, right, certain, well, within reasonable medical probability, meaning, doctor standards, that no material deterioration of the condition is likely to result from occurring during the transfer or the discharge of the individual. And so they're not going to get worse, right, if we put it in like super layman's terms. And most of you, right, got the correct answer that the Sixth Circuit was the one who made this decision. So over here in Kentucky, Tennessee, Ohio, which was kind of interesting at the time. This was before Obamacare, but at the time, right, that this would have been a more Republican area. But the other courts all went a different direction. In other words, the Sixth District Court, basically looked at it and said, this is the plain meaning of the law, right? That you're in the hospital until you're better. But the other courts, especially here in the Ninth, they said, no, you're going to have to show that the hospital got rid of you because you couldn't pay, and that it wasn't for some other reason. Now think back to Dr. Chapman's argument for the evidence, the procedure, and the qualified immunity, right? A similar situation is going on here where all the evidence is going to be in the hands of the hospital. And so how do I get information to bring a lawsuit against these people when they're going to argue that, no, we didn't get rid of you because you're poor. You are poor and you couldn't pay for any of the hospital bills, but we actually got rid of you for all these other reasons, right? And so this is what the judges were trying to figure out. And so they said, well, we can't have a standard of indefinite. It can't be there forever. You have to be able to show that the hospital was basically trying to get rid of you. So again, if we go back to this myth of legality as a formal, neutral process, remember this is, if you search on Google, it gives you this ridiculous ideal of, well, it's just a set of rules that everybody follows, and if you don't follow them, there are consequences. Well, no, that's not true. You've got several situations: police excessive force, killing, and then kicking people out of hospitals because they don't have enough money. Even though the law says that they're not allowed to do that in both situations, people are still doing it, and there aren't any consequences. So in either of these cases, you're seeing a situation or a justice system that's being biased in political affiliation, moral ideology, and politics, right, in their interpretation. So while I agree with the student who said, right, like it should be clear, right, it's plain meaning, stabilize is stabilized, and you should be in trouble if you don't do it, this isn't the real situation. And if you go back to the sovereignty article that I provided for you, this is exactly what happened to Luis Jimenez, is that not only was he kicked out of the hospital, he was quote unquote repatriated, which is a fancy word for kidnapped, and taken back to Guatemala, not by immigration services, not by the United States government, but by a for-profit corporate hospital, in violation of a court order. And so here again, there were no consequences, right? So there is no guarantee that law is going to come in and protect you. So by now you should start to be looking at this diagram and start to see, okay, I get it. Law is malleable. It can be used by different sides to argue certain things. Power is exercised by what is your social position within this system. If you are experiencing injustice, you don't have power, right? You're not going to be able to exercise traditional formal power. You're going to have to look more towards mobilizing protest, and maybe even civil disobedience, like perhaps destroying some things, and that's what you'll see next week's readings. Reminding you, the criminal justice and legal systems are not there to find the truth or to promote stability or any of these lovely purposes of having a system. Their goal is to close cases, and courts resolve open cases, ones that haven't been closed yet, and that's what leads to this idea of tough on crime, which is socially constructed crime. It's showing we are going to go after the things that politicians think are important, not universally important to all people. And then finally, you should start to be able to use the course materials to demonstrate your understanding at this point. And I hope that this has now made it a little bit clearer, and you're building on. You still have one more week's worth of information, plus a little bit more to get ready for the final exam, to show you now that you should start be doing a systemic analysis and to move away from right and wrong, moral and good, and start to look at the systemic issues.